And I requested at the beginning of the meeting that there be an item added under Section 8 regarding a resolution for court order of January 17, 2012.
Yes.
I make a motion to not to take an appeal for the court's order of January 17th, 2012.
Second?
Second.
Second by Jim. Any further discussion on this? Yes.
I think it's worthwhile to just spend a few minutes, and I'd be happy to do it, just talking a little bit about the case. I know that many people have had questions, and now we've had a chance to really review what the order said and try to absorb what it actually means. In my view, based on my reading of the order from the judge as well as discussions with our attorney, the primary finding of this case focuses on a series of non-meetings that the board held while negotiating a separation agreement with the former superintendent. We conducted these meetings under legal guidance as well as guidance from the New Hampshire School Board Association. I personally believe that the board did the best it could with the legal guidance we had at that time. We had a lawyer with us through this process. We used legal advice. So clearly, in my view, when you're looking at the right to know law, there's some ambiguity here. If you can, in my view, unknowingly violate the right to know law with a lawyer present, that's very confusing as a board member, and frankly very confusing as an elected official trying to follow the right to know laws. And I'm speaking for myself here in my interpretation of the case. Additionally, the case that the judge references in her findings is the Ettinger case, which focuses on what I think is a more specific definition of a non-meeting versus a non-public meeting. And ultimately, when I read this, it looks as though going forward, if the board was in this situation again, it should hold non-public meetings as opposed to a non-meeting. So the Ettinger case that the judge references was ruled on in December 2012, and in that case, excuse me, 2011?
December 2011.
Yeah, last year.
Oh, we haven't, yeah, right. What year are we in? All right, I'm sorry. Actually, the Ettinger case, okay, so December 2011. That's right? This case essentially created new case law, which interestingly, we found out, is retroactive. So even though what the board did occurred, I believe, in the spring and the summer of 2011, this new case law that was decided in December goes back. And that's my understanding. And, hey, it's unfortunate. Our case was heard in November. New case law was created in December, and it goes back. So this is a really unfortunate situation, and a lot has been said about it, but I think it's worth noting that we had legal guidance. We were going through this very complicated process, and I think the board learned a lot from this, and that is a really specific definition between a non-meeting and a non-public meeting, and I think frankly the lawyers learned a lot about that as well. I'll go ahead and note there are other findings in this order, including an email that was referenced sent to a quorum of the board, as well as a certain board member's delay in providing documents under a right to know request. And I think those are pretty straightforward issues there are also some posting issues. I think in regard to emails that were not sent, the district has taken steps to address this. We all now have our Oyster River Cooperative School District accounts so that the district can go in and get our emails for requests. And I think that's important. Regarding posting, I'm hoping that the central office is looking at, a way to post, clarify how we post our meetings, and also make sure that there's a backup system in place, because if somebody is sick and a meeting isn't posted and you don't know your meeting is posted and you go to that meeting, you're violating the law. So clearly it gets kind of complicated, and unfortunately the board does not post its own meetings. The board does not post its own minutes, and we probably shouldn't. So anyway, I think there's some things to learn here in terms of a newly clarified non-meeting versus non-public meeting. In terms of our emails, in my view, which should streamline the process, and again, in terms of posting. So I think it's worth noting all of that and taking in the real complexity of this case as it's kind of presented itself. But, I just want to stress that, I think, I'll speak for myself, we were doing the best we could under legal guidance with regards to the majority of the case, and I'm not going to go into specific board members' actions. People can speak for themselves. But, it was a board trying to do the best that it could under a complicated, complex law, and, here we are. And I think it's very unfortunate, and I feel very badly about that. But looking back, I don't know what could have been different with regards to the non-meetings and non-public meetings. So that's just my view on it, and I think people have waited a long time to hear that. This case is final, and we can talk about it, and, I'm happy to do so.
Yes, Jim.
There was references made to Mr. Brackett and myself about the answers we gave in the candidates forum. At the time, the case was still live, and believe me, I didn't know what I could say and what I couldn't say. I will tell you this, that I'm not disagreeing with what the judge found. But I think, in a larger sense, that it was never my intent to defraud the public. It was never my intent to do things behind closed doors and keep things secret so no one would find out. You have to remember, the issue with Mr. Coulter was a very sensitive negotiation between two lawyers. Certain confidentiality had to be observed. I'm sorry if people thought or perceived that we were trying to do something consciously illegal. It was never the case. I'm not an attorney. We did the best we could, and I'm sorry. I'm sorry that we wound up breaking the law,
Violating the law.
violating the law. Forgive me.
Yeah.
There's a difference.
That's all I can say. I'm sorry about that.
Krista?
I just want to say that since the, what do you call them, judgments have come out, see, that's how legal I am.
Orders.
That's how much I know about the judicial system, it's horrible. Anyway, since the orders came out, I have contacted the New Hampshire School Board Association, as has Lee. Lee has arranged for the New Hampshire School Board Association to come in and do our right to know training for the new board. And I have arranged, we have received several advice suggestions from the New Hampshire School Board Association along the process, and this was before the second order came out, as to what to do with our superintendent search, and so on and so forth. So the New Hampshire School Board Association has again been helping us out, just as they did last summer, but this time I'm hoping for a better end result. So.
Any other discussion? Moving on to the next
So
issue.
could
You need to vote on it.
Could you
Motion on the
have the
table.
motion read again, please?
Yes.
Yes.
The motion was to not to take an appeal from the court's order of January 17th, 2012.
Okay. And who seconded it?
Jim.
Jim did. Okay, all those in favor of the motion? Unanimous? Okay.